Great. Your Honor, I'll jump right into rehab if that's okay, or this stay at, more accurately, this stay at Alpine. The dates were June 19th and June 20th, so 2 nights. The
Mhm.
purpose, as she's disclosed to counsel, was a professionally supervised transition to new mental health medications. She wasn't sure if there'd be a negative reaction, so she wanted professional support if it ended up becoming necessary. She did wait until after the June 18th visit, so she wouldn't miss that visit.
So are you
And
saying she was feeling like the meds were on wasn't working that well for her anymore?
yeah, she wanted a change.
Yeah.
And
Okay.
she wanted ample support in making that change and making sure that it unfolded appropriately.
So when she checked in, was that she under a care of a psychiatrist during that weekend? Those couple of days?
Yes, there was a team at Alpine and there was a psychiatrist on team on
Okay. All
staff.
right. Okay.
She also timed it around Father's Day to a weekend that would be spent wherever would be spending with Dakota. So she's trying to minimize the disruption to her parent time. That weekend would have ordinarily fallen on her rotation, but she scheduled it that
Well,
way.
let me ask this about it. Are you saying that she wanted to be under observation in case there were negative reaction to the new cocktail, shall we call it, of uh, of meds that she was being prescribed?
Yeah. Just to help you understand, it is like with switching meds. Yeah, I wanted just like some extra help, like if there was a reaction, and then maybe like to try
Okay.
one, and if it didn't work, then to have someone just like recommend another one. So just honestly a reset and help with that.
All right. Okay. All right. I hear your position on that. Okay.
Council was informed, and he did request documentation, but in this case, Your Honor, you are very familiar with this record, and you probably recall the all too familiar leak pattern in this case, or someone tipping off or leaking information to the media. And my client had some real concerns about this, and it didn't take long for those concerns to be validated. Dakota's roommate and very close friend, Mr. Eaton, has been actively posting online about my client's treatment, including even making a false allegation that it was involuntary.
Well,
In
here's what I would say about that too. I mean, if the parties are restrained from making negative statements about each other, I mean, this is the difficult part with this case where there's so much public interest, right? To what extent do they have control over third parties? Now, if we're talking about one's best friend, there could be a argument perhaps that they're acting on behalf of the party who's restrained, and that could theoretically be a violation. Uh, and I think there's probably some argument that's being raised about whether or not having a private investigator follow somebody around could be a violation of the protective order as well. But it's the way I'm looking at it today is if there's a belief that there's a violation of orders, or if you believe that we need to have specific orders, I'm willing to hear what that is. If it's a violation of an order, I think that's going to require a motion to enforce.
Understood. And the reason I bring this up, Your Honor, is to explain my client's hesitation to just turn everything over to
Mhm.
Dakota. She had
Mhm.
some very real concerns that have been, unfortunately, repeatedly validated over the last 3 months by Dakota, about his discretion in holding on to and keeping that kind of material safe. So we've proposed different ideas here, including potentially allowing a neutral professional to review those documents. My client underwent a drug test at Alpine and has even offered to take another one and has taken one. She took that at Fastest Labs on the 6th, a nail test, a PEF test, and she's awaiting the results, and those will be released to counsel as soon as they're back. Uh,
Okay.
we're
Well,
also,
and that was offered in the matter with Mr. Paul, right?
yes, that's
Yeah.
correct. That's correct. The court, at some point today, I thought you would have it, but it sounds like there might just be a disconnect between the clerks, which is okay.
I have
Um,
it now, the
okay, great.
binder. Yeah.
So in that binder, there is that 3 pages from Alpine, which counsel is welcome to review. At this point, we would
Did you
ask.
not forward it to council before you gave it to me?
That's correct, but I did
Well,
offer the
let's be
chance for
careful
review,
about me looking at it then first. Let's
and
have
that's completely fine.
conversation about that.
That's completely fine. I actually don't care, frankly, if the court reviews those documents today or not. The reason I submitted those documents is because I don't want the court to rely on conjecture, the smoke and mirrors that Dakota has to rely on. Well, she checked into a facility and she wasn't perfectly forthcoming with us, so it must be drugs, Your Honor. She's hiding something. And we don't want to be in a position where the court feels that it can rely on that. And so if the court is giving no weight to that, then we're fine if the court
Well,
disregards those records for the time being.
I'm just want to be clear that there is another dynamic at play here, which is everybody's highly suspicious of each other. And anytime there's blanks where blanks in information, the tendency is going to be to assume the worst. All right. So from my view, more information is better, but I also understand the concern about it potentially being disseminated and getting out to the public, such sensitive type of information.
We're trying to thread the needle, and we think, there are some options at the court's disposal that allow some transparency without something terrible happening, like a disclosure of this information. So that's what we're trying to implement here. And I appreciate the court's understanding of
I mean,
that.
there is a bit of an irony in the sense that they're public figures and they want privacy at the same time. So, yeah.
Judge Mal pointed that out as well. I understand. A few comments regarding PCIT, Your Honor. This has been alluded to in Dakota's status update, and I just wanted to provide the court with an update here. The court's June order compels the parties to comply with DCFS's therapy recommendations, and that includes both EMDR and PCIT. DCFS notified us that they expected the parties to proceed specifically with PCIT. So PCIT was the exact designation used, not some other label.
Right.
Dakota, at the previous hearing, you may recall, proposed using the Children's Center, and we did not have an objection to the Children's Center. My client gave her authorization to the Children's Center after the June 1st hearing, and surprisingly, verbal consent is sufficient to begin that process, which she provided weeks ago. They did later request a written consent form, which she immediately provided the day after the Children's Center sent it to her.
Is this a complaint about something or just giving me information?
It's giving you information because Dakota's alleging that it's being stalled, that we're holding things up. And so I'm just providing the court with some background here.
Okay.
And my client has an appointment scheduled with their clinician today, in fact, this afternoon.
What's her response to the allegation that she hasn't been exercising all of the parent time that she's been awarded up to this point?
Sure. Well, there's a few things that came up immediately. I mean, you may recall at the hearing from June 1st that I requested that the weekend rotation commence that weekend. And it turns out I spoke out of turn. My client did have a scheduling conflict over the weekend. And so that same day, the June 1st, I asked counsel, once I learned this from my client, I asked counsel, Mr. Shattuck's predecessor, if we could switch the rotation so she could still have her parent time. She wouldn't have to reschedule. Figured that would be fine it would be a reasonable request. But the request was denied. Once the request was denied, my client was able to reschedule her obligation and took that weekend with Ever.
Okay.
As far as the June 18th visit, Dakota almost alleges that the June 18th visit was missed. It wasn't. I mean, in his declaration, he kind of leaves it off. He says, well, there was a miscommunication with the exchange person, and he's implying that it didn't take place, but the June 18th visit did in fact take place. June 19th, again, that was a shortened weekend for my client due to Father's Day, and that's why she structured it there. So she did miss the evening of June 19th, or the overnight of June 19th.